dispense of up to 2.5 ounces of prepared marijuana during a 15-day period to a qualifying patient.
It's in the house bill. If you ask a caregiver how much marijuana they can sell to a patient, they will generally say 2.5 ounces every 15 days, because that is what has been built into the statute. That was the intent of the statute, and it was also that's what's required of the dispensaries, which is very clear in statute, 2.5 ounces every 15 days. And that's all, by the way, that an individual can have on their person is 2.5 ounces. So this amendment creates parity, for one thing, and it also makes clear in law what I believe the general practice is for caregivers.
Yes, Representative.
Thank you, Senator. So how would this translate into like oils and things like that? There's no specification here as far as how much, because hearing from some of the caregivers, it takes a whole lot more than 2.5 ounces to make some of these preparations. So can you address that for me?
Yeah, so not being a cultivator or a manufacturer of oils or edibles or anything, I do know, I would prefer to have somebody else speak to that, but I do know in working with the dispensaries, we require the dispensaries to formulate a plan to determine how much prepared marijuana is going into an edible or is going into a tincture, and keeping track of that in their inventory system, in their sales system, to determine how much a patient has received over a 15-day period.
Can I invite Catherine Lewis to speak to that? Might be able to give us some. Don't run off too far.
Hi, my name is Catherine Lewis. I'm with Medical Marijuana Caregivers of Maine, and I am a caregiver. Can you ask again?
I was just curious because it says that a qualifying patient can only have 2.5 ounces dispense. A caregiver can dispense up to 2.5 ounces of prepared marijuana in a 15-day period. So, what happens in a situation where someone has an oil that, or an edible, or some sort of preparation that takes more than that? And how is that all going to get figured out? Like if I had a jar of oil that takes 3, can you understand my question?
The finished product would definitely be less than 2.5 ounces. The problem being is for the patients who want to make their own medicinals, if they came to me as a caregiver, I can give them 2.5 ounces. If you're making a cancer treatment, it takes at least 1 pound, if not 3, for a full treatment. So these patients would then be put in a position where they have to be outside the law in holding on to the 2.5 ounces. They have to wait 15 days and wait another 15 days and wait another 15 days to try to accumulate enough of the raw material to make the amount of oil they need to do a treatment. You can't start one of these treatments and then stop and then wait and then start again for it to be effective. As a caregiver, if I have the appropriate materials and licensing, then I could make the oils for them, but it's going to take that same amount at one time, but the product that's getting to the end consumer may only be 60 grams versus 3 pounds.
So virtually everybody's, if they need that much, they have to be illegal somewhere along the line.
Yes, unfortunately.
Yeah, thanks. So, we're talking waivers today, big waiver day. Is there some thought about some kind of waiver where people aren't qualified, have some qualification, and patient mix who want to head into this territory? I'm imagining most caregivers are not wading into this kind of territory, but is there some kind of waiver that would allow this kind of use without expanding the whole?
So somebody speak to Mr. Allen?
Sure. Ken Albert, Maine CDC. The department is the only one to take a look at a waiver process that would look at, under those circumstances, authorizing the creation of that particular cancer treatment.
Representative Sanderson.
Thank you. In the meantime, what do they do?
We could build the waiver process into the statute and we promulgate the rules. I mean, if they wanted to call and speak with us directly, I believe that we could have the authority, under current law, I have to look at that more carefully, but I can see if we have authority under current law to attempt a waiver for that particular process. I would like to think that the current law would not prohibit a patient from receiving the form of medicine that is most effective for them, and if that's the most effective form for them, I would like to find a way to make that happen, is what I'm saying.
We'll move on and stuff like that.
All right, let's flag that for now.
Okay.
I,
Mr. Chairman,
sure, if you'd like to come up there quickly.
Senator Brakey. My name is Dan Walker. I'm an attorney with Credit Clarity. I represent Wellness Connection in Maine. Just wanted to say that the dispensaries do operate under that 2.5 ounce every 2 week limit. And so if you are considering lifting this, then you should be lifting it for the dispensaries as well, so they can all operate under the same thing. But if you're not, then we would also operate under this waiver process, keep in the limit for everybody, and then everybody can operate under this waiver process. Either way, just make it the same for everybody.
Yeah.
That's all I have to say.
I do think that's a good point, that if it's a good policy, it should be a good policy for everyone. If it's bad policy, it should be a bad policy for everyone, and let's try to, whatever we do, let's try to have it.
Just keep it the same. Thank you.
So, all right.
Senator Brakey, just in response to that, I do believe that the department, in the current law, under section 2423, subparagraph 8, creates an exception for a patient who has been using their medical marijuana, an exception to the criminal code. So I think we could probably work with that statutory framework there to create a waiver system in the interim to address that issue.
All right.
Okay, moving on to section 22. 3, department approval or denial. There was new language. In the new language in that chapter, there was a little question about the words where it says the applicant has, quote, acted in bad faith with respect to. We'd like to change that to, on the second line that's underlined, line 8, to this chapter, or the applicant has violated the laws and rules governing the use of marijuana. So acted in bad faith with respect to will be crossed out and changed to violated.
And Representative Sanderson, if I remember, that's basically because there was concerns about what's considered bad faith, and
Yes.
just trying to make it clear cut.
Yes, violated the rules, it's much more clear than acting in bad faith. Okay?
Representative Gattini?
Are these issues as we go through things that have been agreed to between you and the department is electronic? Gotcha.
Yes. Okay, moving on to section 34, on page 9 of the bill. The revocation of the caregiver certification card. In the instance where a card may be revoked by the department, there was concern on part of the individuals of whether somebody would be required under B, section B, line 36 and 37, to dispense with their own medication if they were cultivating for their own. So Mr. Albert and I have agreed to have language stating a primary caregiver whose registration card has been revoked shall, in accordance with this chapter, dispose of all medical marijuana in any form, and then we would add, for designated qualifying patients. And that would allow them to keep their own, for their own personal medicinal use. Page 10, section 36. Here's where it gets fun. Okay. Under, in compliance, okay, under section 3 and 4, registered primary caregiver penalties and registered dispensary penalties, on line 15, where it reads, not less than 200 and not more than 500 per day must, we've agreed to change that to may be adjudged. And then line 16, 17, and 18, that will be deleted. On number 4, same thing on line 21. That word must will be changed to may. And then the sentences, each day of the violation constitutes a separate offense, and following a person at the time of the violation, provisions found, chapter class D crime, those will be deleted as well in those two sections. 5 and 6 stay the same. To have clarity regarding when these penalties kick in, on page 11, we will add 10. And we will be adding language asking the department to develop rules regarding technical assistance, which would help individuals come into compliance, findings, and corrective action plans, and lay out their process for that.
Is that anything? Develop the rules regarding technical assistance?
The findings and a corrective action plan in the case of any findings of deficiency.
If I may also, just for information purposes here, so to go into the compliance sections, the department in and of itself does not have jurisdiction to impose these fines. We would have to petition under the current statutory framework, we would have to petition the district court, and so it would be a court of law that would determine whether or not the department could carry its burden of proof to secure these fines.
As a clarification, that would only be after a finding, deficiency, plan of action was executed, yet not followed through on behalf of the individual.
Ongoing non-compliance.
Absolutely.
Representative Gattini.
Thank you. So again, there's no proposed changes in section 7.
Explanation.
Okay.
Section 7?
I'm sorry, the injunctive release section of the compliance, I'm sorry, section 36.
Okay.
Basically, it's beginning of line 39, going through the next page, line 8.
Right, I did confirm with the Attorney General's office that this language is standard language, and the rationale that was given to me was that, again, when there's a court order in place, and if somebody, it should not be contingent upon taxpayers of the state to prosecute a situation where somebody's violating an existing court order. So in that case, it shifts the burden over onto, it shifts the burden to the individual who's been brought for injunctive relief.
So this is,
I'm sorry.
so this is if there's already been a court order and the person remains out of compliance.
Or if we are pursuing a violation, if we file a petition with the district court, we have an interim order, or we file a petition for injunctive relief. And if by the time we get to that point, generally, it could be either of those situations. But in either case, the philosophy is, or the basis for the law is that it should not be the taxpayer to bear that burden of paying for that type of injunctive relief.
And I understand that. I understand the philosophy and the idea, so I'm really still trying to understand how this analogizes with other healthcare entities that the department, that the LRS actually has oversight over. So, for example, the department has the ability to go hand in hand with the Attorney General's office, Superior Court, and seek receivership over nursing homes or hospitals. There are probably other places in your regulations of other entities that the LRS regulates and licenses. And again, are there specific provisions in those statutes and in those regulations that will allow the Attorney General's office to seek fees and costs when the department and the Attorney General go forward and seek injunctive relief or receivership or impose fines or anything that's analogous to this? That's really where I'm trying to see how similar this is.
The last time that I recall the division pursuing that was with a licensed child care provider, home child care provider, where there was ongoing, operating with over numbers on an ongoing basis, multiple rule violations over and over. Finally, we went to petition for closure, emergency closure. She failed to respond to the emergency closure order. We went back to court for injunctive relief for yet another order, and at that point, that's when the Attorney General's office wanted to impose this particular provision of law, and we sought that out of the court.
And what happened? Was it granted?
We don't know the answer to that.
Other than the punchline.
I was so excited.
I think the court reduced the overall fine for her, but did impose the cost.
I'd like to see where, in the rule or the statute, it actually gives you the specific authority to do that. Because maybe there's general authority to do that, and you don't need that language in statute, and you can have that battle someday when you actually take one of these entities to court. Just an idea. I don't know where I am. Thanks.
Senator Haskell.
Thank you. In section 9, there was a question at one point about the preponderance of evidence as opposed to beyond reasonable doubt or clear and convincing, or whatever that language ought to be.
We're on page 2.
I am on, I'm sorry, yes, on page 11. On the very last, line 15 on page 11. Preponderance of the evidence was a term that came into question, and the question was whether or not we needed a different legal standard. Beyond reasonable doubt or clear and convincing or something like that.
This is the administrative burden, Senator Haskell, so the reason we actually have sought to clarify that is in working with the courts, because of the criminal violations that may result as a result of behavior of operating outside the Medical Marijuana Act, there's confusion around what burden the court would apply in an administrative proceeding as opposed to a criminal proceeding. So we were finding ourselves having to challenge the court on the burden of proof. So this is the lower burden of proof than the criminal burden, obviously. So that's what we just wanted to clarify. That's a good point for a judge, point to a section of law to aid that judge in the appropriate burden for an administrative proceeding.
Additional questions, discussion? Philosophical grants? Yes.
I just wanted to point out one thing in section 25, I believe, or actually give me 1 second so I don't point you to the wrong. Section 26, I think, which is on the bottom of page 7, deals with the change to a statute dealing with confidentiality, and I had that circled as needing to go before the Judiciary Committee before it's able to be enacted. So I just wanted to make the committee aware that I think that additional step, and that all it is, it would be sending this over in a memo form and explaining the interest between public disclosure and the reason for keeping it confidential, and they would have an opportunity to take a look, just like when you create a new crime and just before criminal justice.
Is now a complaint being the complainant being confidential? Is there any place in law where that's not the case, or is this consistent with? I guess is this consistent?
Senator Brakey, from the Division of Licensing, it's consistent across healthcare providers. It's consistent across our division as a complainant. Otherwise, it would have a chilling effect on an individual coming forward to complain. So again, this is not in the criminal arena where the accused has a right to address their accuser. This is in the administrative arena. We do tell complainants, however, that if the information that they're complaining about, we may have to come back to them and ask them for permission to give their name if we use it in an administrative proceeding or if it ultimately ends up in a criminal proceeding. They're aware of that, which is why they're also allowed to offer up a complaint anonymously, which the department would prefer not to have that scenario.
And again, just to follow up on that, I wasn't in any way implying that this raised any
Oh, yeah.
constitutional
I know.
concerns, just that there's another step to the process.
But since you brought it up, I had it in my hand. So, Representative Sanderson, did you have your hand up earlier? All right. Any additional discussion? Additional discussion. I'm not sure exactly how we want to proceed right now. We don't have a motion. We don't seem to have any more additional discussion. We could have a motion. We could talk about where we want to go now. We could corner caucus. We could do any number of things. Representative Sanderson.
I guess the next step is the committee ready to take any action, or if they want any more discussion?
I'll just say, having sat down, going through the public hearing on this and being very skeptical of what was contained in this bill originally, having sat down and talked with representatives of both the caregivers and the dispensaries on this, understanding a lot of their concerns, addressing many of those concerns, and working with the department on addressing some of those, I'm very much more comfortable with this than I was when it first came to us in the public hearing. Senator McCormick.
Thank you, Mr. Chair. I feel pretty confident after going through the amendment myself, so I make the motion not to pass as amended.
Is there a second? Is that a second? Second by Representative Bashon. Discussion? Representative Guttini.
Yeah, and again, I'm just going to reiterate what I said. I mean, there might be some very good things in here. I'm not willing to vote in favor of this until I understand kind of the totality of where I'm going to be on all the other issues. So, I mean, that doesn't reflect what any other member of this, if we're going to vote now without having a good understanding of what we're going to do with the other bills, I'm going to vote no on this. And then when we work the other bills, there might be some things in here that I'm more than willing to amend into the other bills. So, again.
Okay. Can we corner caucus?
Thank you.
Yeah, no, I'll just put my chair. and we'll work them all together. I would like to briefly address the bills that are
Yeah. No, I think it's a good idea. I think it's a good idea.
Yeah.
Have fun. Say fun with that.
The motion on the floor is on to pass as amended. That being said, I would entertain a motion to table. Oh,
Okay, sorry.
all right, before we do that, I think there's some discussion on it. Representative Sanderson.
Well, it's not just discussion. I think after waiting all day, these folks deserve an explanation of what we're doing at this time. I mean, I think we have a general consensus, but I do respect Representative Coutin's feelings about wanting to see where we're going to be going with other bills as a package. And if tabling this today until we have time to work all of them in conjunction can get us a unanimous vote out of this committee, then I think he deserves that due respect from the rest of us, and we're willing to do that to accommodate.
Representative Henderson.
Thank you, and I really appreciate this approach as well, because in my district, living right at the border, New Hampshire, and having a big growing facility with caretakers who are in one big box, that are, it's kind of a sharecropper arrangement. I'm aware of a lot of problems, and I'm trying to walk the walk of mitigating those problems with enforcement, and not take away the caregivers' opportunities to express themselves through their knowledge of their agriculture. And so I'm trying to walk that walk too, and I think looking at all these bills in total will allow me to do that better. So I appreciate this.
Thank you, Representative. Senator Haskell.
Yeah, I'm just going to throw a couple cents in thinking it too, because this is not an issue that I take lightly. And so consequently, the interaction and intersection of these bills to me is very important. And where we come out at the end is very important too. And I have been saying that to my co-chairs and my fellow caucus members in each of the meetings we have. So this is not a limited perception that we need to do this in a unified way. And so I do appreciate the committee's indulgence in us working as hard as we can to get as much as we can right. Thank you.
Additional discussion, Representative Sanderson?
If there's no other discussion, I'll move to
All right. Is there a second? I'm going to give it to Representative. Moved and seconded by Representative Sanderson and Representative Coutin. To table, all in favor, please raise your hand. All opposed, it's unanimous, So, Representative Sanderson?
There was a request from Representative Hyman, Representative Hammond, for a marked up version of those proposed changes, and I'd be happy to download the Word doc and show the markup and send that out to the committees sometime this week.
Thank you. I know we have four bills still before us. They're all have been tabled. So we don't necessarily, if we have reason to take them up, we can, but we don't need to necessarily take all of them up if we're not ready to go on them. LD5 is an act to remove the limit on the number of patients a primary caregiver may provide for under the medical marijuana laws. That's duplicative of some proposals in other bills, but I wanted to keep it around just as a vehicle in case we need it. But as soon as so I don't think we need to take that up. The other two bills we have that are in this sphere of the regulatory world of the industry is 726, an act to increase patient safety in Maine's medical marijuana program, and LD 1258, an act to amend the Maine Medical Use of Marijuana Act with regard to good business practices. I imagine if there's some things we want to talk on or work on there, these are kind of in the sphere. I imagine if we take them up, we want to table them again and work them with the department bill. LD 752 is an act to permit medical marijuana cultivation by incapacitated adults. This is something I'm sure if we wanted to and we were ready to, we could take up and vote on. We're not ready? All right, I guess we're not ready to vote on that one. So, yeah. Senator Hassel.
My question, I, like the rest of the committee members, I'm ready to work as long as we need to, and if there's anything that we should have under consideration on these bills, I'm glad you're here today, because it is still very much ongoing management. So I just put that out there, if anyone's got amendments or something that we ought to be looking at, I'm ready to, if not, I'm glad to do it.
My impression is that these are ongoing things, but Representative Sanderson.
Yeah, as a sponsor, a couple of these bills, one of which, could be rolled in with another or et cetera. I think I think we've done a lot of work to try and find consensus on some spots. We're still apart in others, and I still think it would be beneficial rather than laying something out today of what's been done in working with these bills, that we continue to work with the dispensaries and the caregivers to find consensus. So when we next work these, we come in, we offer a cohesive plan that is agreed to, and we all agree hopefully as fair as can be to everybody, and be able to present that to the committee to have a discussion on, and then we'll be ready to take an up or down vote on it without these fits and starts and stops. So, when do you think we would be taking these up again?
I hope not Sunday. Wednesday.
Wednesday, well, okay. I mean, if it's Wednesday, I think we, as a sponsor of the bill, we can just make it happen. Make it happen. And be ready to come in Wednesday with as finished a product as we possibly can, which may not please everybody all the time, but at least try to get as close as we can.
One thing I just wanted to get on the record very quickly, so I was slightly excited for this. Just on the bill that we just tabled, I had said that we sat down with some of the representatives from the caregivers and the dispensaries and worked through some of those things. We did address some of those concerns, but I did not mean to imply that all of those concerns have been met and that there are not some concerns that remain. So I just wanted for clarity, since I did say that on mic, and I think it was misunderstood, or is my intent was misunderstood. I just wanted to say on mic to clarify that, so I'm not getting anyone in trouble, I'm not getting myself, most importantly, I'm not getting myself in trouble. I do not intend to say that there are no objections or no concerns about what makes the amended bill. I'm technically,